All right, well, welcome, ladies and gentlemen, to this MCJ Report exclusive. That's right, usually we don't broadcast on a Sunday, but I assure you that there is a good reason why we are. So, first of all, welcome to the broadcast. Go ahead and give it a share, ladies and gentlemen. I'd like to thank you for being here this evening. I can see a whole bunch of you tuned in right now, so welcome to the show. We have some breaking news. As you can tell, it's probably something important. I'm wearing a suit jacket today, that's right. For those of you who watch the MCJ Report, you know that I usually don't wear these things, but you know what? I'm not going to keep you waiting. We're going to get stuck straight into it. So go ahead and give the broadcast a share because we have a very important announcement to make. All right, so let's get this started, ladies and gentlemen. All right, so the Victorian Chief Health Officer, the Cho Brett Sutton, to appear in the Supreme Court. All right, so what are we talking about here? This is nothing in relation to Sluggate, so okay, it's got nothing to do with that. Now, before I go any further, ladies and gentlemen, I just want to put a few disclaimers in here. First of all, here at MCJ Report, myself included, obviously, as the host of MCJ Report, we have the full blessing of the solicitor involved in this matter, and he has granted us permission to break this story first, okay? So this is the first true MCJ exclusive. Now, before I explain before we go into detail about what this lawsuit is and how it came about, and we will hear from the lawyer on this particular segment of MCJ Report, I'd first like to put the lawsuit in context so you can understand it a little bit better at home. Now, I didn't want to risk leaving anything out, so I'm going to be reading off my notes here verbatim, just so that nothing is left out. So these notes are my own. These are my own words. So I'm just going to get started. All right. So, it is the opinion of many that lockdown policy is disproportionate and results in immeasurable and unjustified damage to society. The basis for lockdown policy is determined by what the government refers to as positive COVID-19 cases, which are largely based on the results of conducting a testing method called real-time RT-PCR, which stands for reverse transcription polymerase chain reaction. It is also the opinion of many that RT-PCR as a method for diagnosing SARS-CoV-2 infection in patients is not just unreliable, but entirely not fit for purpose. Okay, so it is for this reason that on the 14th of August 2021, Mr. Jonathan Edward Kingsford Andrews, a Melbourne-based lawyer and principal from Bose & K Solicitors, lodged a lawsuit against the Victorian Chief Health Officer Brett Sutton and the Associate Professor. I'm going to read to you now the complete press release. All right, so dated here the 28th of August 2021, here is the press release. Supreme Court of Victoria legal action by plaintiff Jonathan Andrews against defendants Professor Brett Sutton and Associate Professor Michelle Giles regarding the reliability of COVID-19 PCR testing. Plaintiff and solicitor Mr. Jonathan Edward Kingsford Andrews of South Yarra, Melbourne, and principal at Bose & K Solicitors lodged a legal suit against the Victorian Government Chief Health Officer and Deputy on 19th August 2021, which was subsequently listed on the 24th of August 2021. The purpose of the suit for the court to examine: 1. The reliability of polymerase chain reaction nucleic acid testing, PCR testing, commonly known as the COVID test, for checking infectivity rates among the population of Victoria, having particular regard to, quote, false positives being reported as actual cases as basis for the state government, quote, lockdowns. Whether the Victoria State Government has used emergency powers to suspend civil liberties that were based on unreliable medical data and are therefore invalid. The defendants were process served the originating motion and affidavit Jonathan Andrews on 27th of August 2021. No listing date has yet been set by the court. And here it is signed by the solicitor Jonathan Andrews from Bose & Kay Solicitors. All right, so just coming back here, ladies and gentlemen, we have our solicitor. We conducted an interview earlier today. It goes for around 15 minutes where I ask some questions and we have some questions answered. Now, I'm supporting this. I've been sort of sitting on the sidelines looking for legal action that I felt had merit, and I've been looking since the inception of this corona situation, and I'm very excited about this. So without further ado, ladies and gentlemen, I'm going to bring Jonathan on and play the interview that we conducted earlier. All right, we've got Jonathan here with us. Jonathan, welcome to MCJ Report. And to start it off, could you please tell the audience, why did you decide to file this suit?
Hi, Morgan. Thanks for having me. Naturally, being a Victorian, I've been suffering the effects of the decisions of the government with regard to the COVID PCR tests, and it was really a matter of looking at a way to have this addressed by the courts. But this particular matter has to do with the medical data. So the case is essentially saying that, look, unless you can prove that this medical data that you base this decision on is valid, then we're saying that these executive decisions are therefore by default also invalid. Okay. That's the basis of the action.
Okay,
so
perfect.
They will then have to bring we're essentially auditing the Chief Health Officer and obliging him to produce that data to the court, and more specifically, so there's two main limbs to it, if I can get into it. Two main limbs to it are, one, we're going to examine contrary expert opinion as to whether the RT-PCR test is a valid form of testing for corona, for COVID-19, or otherwise known as SARS-CoV-2. And the second main limb is to deal with, given the complications in applying this test correctly, as per the WHO directive released earlier this year, which has to take in various factors such as, I'll just note a few here, has to take down various factors, whether these have been applied correctly by the Victorian Department of Health. And to that end, we note that the WHO directive dated 13th of January 2021, it's called the WHO Information Notice for IVD Users 2020/05 nucleic acid testing technologies that use PCR for detection of SARS-CoV-2.
Yeah, excellent, and we understand that. Now, just as a point of reference, Jonathan, it mentions on the press release that the defendants have been, quote, process served. What exactly does that mean?
Well, right, so process service is simply what occurs once documents are filed with a court pursuant to a legal matter, be it civil or criminal. The other side essentially has to be notified that there are proceedings afoot. So the process for that is for that side to be served documents by either personal or ordinary service, depending on the seriousness of the matter. So on the 27th, we process served the Chief Health Officer. So it was Professor Sutton in his capacity as Chief Health Officer. So I should emphasize that it's not against him personally, but simply against in his capacity as Chief Health Officer, as well as Associate Professor and Chief Health Commander, Michelle Giles. because she's also involved in the decision-making process. And the reason why they were named on the originating motion is because they are, to our knowledge, the responsible officers providing the medical data via the PCR testing to the Premier, Mr. Daniel Andrews, for him to make executive decisions with regard to COVID.
Okay, yeah, that's all very much understandable. Now, for many of us, we don't understand a lot of this legal terminology. So let me ask you a question. What happens if the defendants in question simply don't show up to court?
Yes, I just have to make a quick amendment there. It's actually Deputy Health Commander is Associate Professor Michelle Giles' role. So just a quick amendment there. Sorry, could you just repeat that last question?
Yep, no problem. So the question is, for those of us who don't understand the legal lingo, what exactly does it mean, or what would happen if the defendants simply do not show up to court?
Well, it's a civil action, and it's under common law, and it falls within the Judicial Review Division of the Supreme Court. So as with any court process, should a named defendant fail to show up to court, well, that could constitute contempt of court, which could involve sanction by the court against the defendant.
Okay.
So in other words, they have to show up, or have their representatives show up. If they don't show up, they'd want to have a very good reason as to why only their legal representatives showed up in their stead. But ultimately, it's up to the court to decide what to do. Should they, act in a way that's considered contemptuous?
Okay, that makes sense.
So presumably they will show up.
Okay, we'd like to presume so. So definitely.
Yeah.
All right, now, Jonathan, could you please tell us roughly how much would this cost, this suit with the Supreme Court, and where and how will the funds be spent?
Well, I am the plaintiff and solicitor for this action. So I've paid personally for the filing, which is around $800, and I will then be essentially at the moment I'm funding myself. There is a site for making donations. I'm sure we'll cover that later. But
yes.
The Victorian government has all the legal apparatus and other resources to employ in order to fend this off. So my understanding, having consulted with the Law Institute of Victoria, one of their senior counsels there, is that they are within their right to retain a senior QC or SC in order to assist them in defending this matter, and they can charge up to $15,000 a day. So it can get very expensive, but it's really just a matter of the action has to proceed. I mean, how much more are we willing to take?
Could you please talk to us a little bit about how transparency will be upheld during this process?
You mean with regard to funding of this action?
That's correct, yes.
Okay. Well, we are, we being me, myself and I, and others that wish to assist in the legal matter, surely they can go to covidvictoria.com.au or GoFundMe, COVID Victoria Legal Action. They can, make a donation. They can also contact me directly via the email provided, which is jonathan@covidvictoria.com.au. If they have some legal expertise and they're willing to work in a paralegal capacity or in other secretarial capacity, then we're building a team now to do this action. And I think that people need to be mindful of and look, we're willing to do reports with you if you'll have us on a regular basis in order to update you as to what's going on in the court.
Absolutely.
And you know, we don't have anything to conceal, but this is really an emergency in terms of we have given away so many civil liberties on the basis of this perceived threat, perceived or real. However much turns out to be correct after all the evidence has been examined. So with regard to the funding, all the funding goes towards this. It goes towards any subsequent battles. People have to keep in mind that, you know, on the website we're canvassing for 150,000. Well, this case could easily, an adverse ruling could easily be 60 or above that, or even if we do have a victory, they can also appeal, and vice versa. We can also appeal. So, but now is the time. Now is the time to support an action that you believe in, because not only an action you believe in, but an action that you believe is going to be effective. So this is why we've gone down this path. This is why we've chosen this particular action, is because we believe it's going to be the most effective.
Perfect. And we really appreciate that, and thank you for the transparency, and absolutely we'd love to have you regularly on the show to give updates as we go along, and I do appreciate that. Now, before we wrap this up, Jonathan, I understand that you'd like to read a statement from the affidavit, so would you like to go ahead with that?
Yeah, thank you very much, Morgan, and I really appreciate you having us on today. And I thank you personally for your ongoing service, you know, to your country, because this is what it's coming down to. We have to stick together. We have to find at least a basis to stick together, because united we stand and divided we fall.
100%.
American
100%. We have to
goes.
work as a team, and this is becoming an urgent matter, wouldn't you say, Jonathan?
Yeah, well, it's an emergency. It's an emergency. We don't know how bad this is going to get. I think the positive news is that people are getting upset, and they are starting to question what's going on. Because initially we were told, well, if we just lock down for a few weeks and follow what the executive orders state, then, you know, this will all be relaxed. And then we had the same advice with regard to taking on vaccinations, and again, that's now being reviewed. So I don't know what, you know, they are part of the action is actually we're questioning whether the Victorian Parliament, when they created these emergency acts in 1986 and 2008 respectively, envisaged that they would be used in the future for lockdowns extending beyond 18 months, i.e. more than 1 month, and every month thereafter under the Act that you are supposed to redeclare a state of disaster, as it's termed in Victoria. So did they envisage that? But moreover, did they envisage these emergency powers being used as a basis to compel members of certain occupations to take a provisionally approved vaccine under force? I would say on the balance of probabilities, that's not the case.
There's a lot of questions. Yeah, absolutely. There's a lot of questions that need answering, and I think the PCR tests are probably one of the biggest, if not the biggest, pieces of the puzzle.
And it's a good place to start. So thank you for that. And I'll read out what I put in my affidavit, just because I thought it was quite concise. And I also wanted to bring to the viewers' attention what their respective rights are, both on a state and federal level in Australia, because sometimes I think we need a little reminder. But so just quoting from my affidavit, to this end, the constitutional mandamus, that means an order from the court, is respectively sought for the purpose of obtaining best evidence from the Chief Health Officer designated under the COVID Act, namely Professor Brett Sutton and or the Deputy Health Commander, Associate Professor Michelle Gives, within 30 days of the order. That the hard scientific proof be produced to this honourable court, with the overarching purpose of its examination being to remove any doubt as to the validity of the bases of the state government's declaration. Furthermore, should the CHO and or DHC fail to produce the hard scientific proof, it be held that as a result of the invalid invocation of the emergency measures by the state government, it has encroached upon my rights and responsibilities enshrined in the Charter, that is the Victorian Human Rights and Responsibility Act 2006, including but not limited to the right to protection from torture, cruel and inhumane treatment, Section 9, the right to freedom of movement, Section 12, the right to peaceful assembly and freedom of association, Section 16, and right to fair hearing, Section 24. That as a result of the application of emergency measures by the state government is encroached upon my federal constitutional rights enshrined within the Australian Constitution, including but not limited to implied freedom of political association, Section 7 and 24, express freedom of religion, and for that matter, congregation, i.e. being able to go to church, synagogue, etc. Section 116, express freedom from prejudice against state of residence, i.e. freedom of travel between states, Section 117, and implied right to the rule of law. That a result of the foregoing encroachment to my civil liberties by the emergency measures in the COVID Act, I, along with millions of other Victorians, have suffered psychological distress, economic and non-economic damage, and limitations to access to justice within the court system. Anyway, that's just an excerpt from the affidavit, so people have some understanding as to what the court will examine.
Thank you. And Jonathan, I'd like to thank you for your time, and we certainly hope to have you back on the show really soon.
Thank you very much indeed, Morgan, and thanks for the viewers for watching.
Thank you.
God bless.
God bless you. Oh, sorry. Okay, I think my volume's back now, ladies and gentlemen. My mistake. Let me just, first of all, thank Jonathan for his time. Jonathan, thank you so much for taking the time to address this matter with us. Now, ladies and gentlemen, it's my opinion and the opinion of many that PCR tests play a crucial role in this corona situation, and challenging whether or not these lockdowns can be justified based on the PCR test results is quite possibly the most important question that needs to be answered, or at least one of the most important questions. Now, for the record, I'm not just promoting this action. I have committed to working alongside with Jonathan in order to work towards achieving the best outcome. And Jonathan will be appearing regularly on the show in order to give updates as to the progress. All right. So if you would like to support this legal initiative, you can donate via covidvictoria.com.au. All right. So that's covidvictoria.com.au. The link is in the description. So please go ahead and share this broadcast absolutely everywhere. We're going to re-upload the broadcast onto all platforms, and we'll have Jonathan back on MCJ Report really soon. And once again, that's covidvictoria.com.au. So I'd like to thank each and every one of you for your attention tonight, and we'll be back really soon. So in the meantime, enjoy the rest of your weekend, stay strong, and we will be live once again tomorrow night, 8 p.m. Australian Eastern Standard Time for MCJ Report. Okay, take care, ladies and gentlemen.